Good day, Crime Talk aficionados. Yes, it is Sunday, which means it is a time for the weekly recap of all of the top stories throughout the week of September 2nd, really the 3rd because of the holiday, of 2024. All conveniently located in one location. I hope you enjoy the show. First, the Brian Kohbgerger matter. The judge in the case of Brian Kohbgerger says that he is facing a challenging decision regarding the venue of the trial of Brian Kohbgerger, who is obviously accused of fatally stabbing 4 University of Idaho students back in November of 2022. Now the judge, whose last name is Judge John C. Judge, is contemplating whether to move the trial about 300 miles away to Ada County, which is Boise, to assure a fair trial. Now, during a hearing back on August 29th, the judge acknowledged the weight of the decision, stating, quote, "This is probably professionally the most difficult decision I've ever had to make." The judge is considering the arguments presented by both the defense and the prosecution before making his ruling. Now, the murder of Kaylee Gonzalez, Madison Mogan, Zaina Kernodle, and Ethan Chapin obviously shocked the community and led to a 6-week manhunt of Brian Kohbgerger, who is the prime suspect in the case. Now, Kohbgerger was arrested back in December of 2022, and after entering pleas of not guilty in 2023, Kohbgerger has a trial set to begin next June. Now, what is the argument for the change of venue? Well, Kohbgerger's defense team has argued and presented a lot of evidence that there has been intense media coverage, and that has created such a biased environment there in Latah County that it is basically compromising his right to a fair trial. Now, the defense presented witnesses who expressed concern over the community's sentiment towards Mr. Brian Kohbgerger, with some residents suggesting that there would be violent repercussions if he was acquitted. Now, the attorneys representing Brian Kohbgerger, the lead attorney, Ann Taylor, emphasized the need for a change of venue to protect Brian Kohbgerger's constitutional rights. Now, in contrast, the prosecutors argue that they can get a fair jury seated in Latah County, and they note that, hey, there's been extensive media coverage beyond the local community, and they also stress the convenience of keeping the trial in the area for the victims' families. The father of victim Kaylee Gonzalez, Stephen Gonzalez, has expressed confidence in the community's ability to judge fairly the case, labeling the venue change request as irrelevant. We'll have to wait and see. Anyway, Kohbgerger's defense has raised concerns about what they describe as a mob mentality against him there in Latah County, citing statements from local residents that suggested violence if Kohbgerger were acquitted. They also conducted a survey indicating that 70% of the locals believe Brian Kohbgerger is guilty, further supporting their request to move the trial to a larger jurisdiction, in this case, Boise, Idaho, so that there's a larger jury pool in which to pick. Now, the trial is currently set to begin on June 2nd of 2025 after Kohbgerger waived his right to speedy trial. And since it is a death penalty case, there have been pretrial motions, and there will be even more pretrial motions in the coming future, which obviously take time as well. So we are all waiting for the decision of whether to change the trial venue. Obviously, it's pivotal, and it could impact whether it is perceived as a fair proceeding. We'll have to wait and see. Now, Judge is expected to announce his ruling after thoroughly reviewing the arguments from both sides. I get the fact that a crime should be tried generally where it is committed. That is a fundamental tenet in our Constitution, that a crime should be tried where it took place. However, there are exceptions to all rules. And the exception to this particular rule is that you have to have a fair jury pool. If 70% of your population has said that Brian Kohbgerger is guilty, pretty good odds that, well, you're going to have to bring in a lot of jurors. It doesn't say it can't be done, but this is a death penalty case. Why risk it? I don't see what the judge is troubled about or what he is contemplating in this particular situation. I think it's rather clear. Move the trial to Boise. Don't create appellate issues. One of the things the judge has to consider, even though they may not like it, is that you have to protect the defendant's rights. And from there, then you can protect the record, which means no appeal when, in fact, he is convicted. Richard Allen, who is having a bad day? Yes, Richard Allen and his attorneys, because the special judge, Francis C. Gull, is not going to allow Richard Allen's defense attorneys to present its third-party murder theory in court. Now, in the order that came down today, Judge Gull granted most of the state's motion in limine seeking to prohibit the Odinism theory from being part of the case. Now, for those who may not know or don't recall, Richard Allen is charged with 4 counts of murder dating back to February of 2017 in regards to the death of Abby Williams and Libby German near the Monon High Bridge in Delphi. Now, the Indiana State Police announced his arrest back in October of 2022, more than 5 years after the girls were killed. Now, since then, the case has been bogged down by some contentious legal back and forth that involved not only the attorneys, but the judge herself. And Allen's lawyers have contended that someone else killed the girls, outlining their theory that a group of Odinists were responsible for the death of the girls. Now, the defense first revealed its alternative murder theory in its motion for a Franks hearing, challenging the validity of the search warrant granted for Allen's home. Now, the defense has tried to focus on multiple individuals who it maintained are adherents of Odinism, which is a pagan Nordic religion co-opted by white supremacists. Now, Allen's lawyers have attempted to shift the blame for the murders to these individuals in several pleadings that they've filed throughout the case. Now, the prosecution has maintained that the defense has relied on nothing but speculation and hearsay and has not produced any specific evidence tying any third-party perpetrator to the killings. Now, the prosecutor filed a motion in limine asking the court to bar the defense from mentioning the alternative murder theory suspects or any third-party perpetrators during the trial. So in the judge's order that came down today, September 4th, Judge Gull sided with the prosecution, writing that the burden was on the defendant to show the nexus between Odinism cult or ritualistic killings and specific individuals cited in the defense pleadings. Now, she noted the case law is quite clear that the nexus must be based on not on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. She also noted that the defense had failed to produce admissible evidence demonstrating such a nexus during the hearings that were held last month. Now, the court states in the order that the court is not going to permit the evidence to be submitted by the defense in support of their arguments regarding third-party perpetrators in the trial of this case, as the probative value of such evidence is greatly outweighed by confusion of the issue and its potential to mislead the jury. The judge noted that the ruling came despite objections from the defense, but she did leave a small door open for the defense by writing that the court would allow evidence to support an offer of proof at the trial if one is made by counsel. Now, the jury selection is set to start October 14th, with jurors coming from Allen County and then transported to Carroll County for Richard Allen's trial. That trial is scheduled to wrap up sometime in mid-November. Now, that's a lot of information that we provided to you. You would think that the special judge, Francis C. Gull, would have issued a lengthy order explaining her rationale for this, but she does not. Let me show you, ladies and gentlemen. This is the court's order. So everything that I explained to you, I explained in a little greater detail than the judge explained her order. This is the gut of her case. I think it's just important to note. As it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, Ron Logan, and the murders of the 2 victims. The case law is quite clear that the nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. The Court finds the defense has failed to produce the admissible evidence demonstrating the nexus between Odinism, cult, or ritualistic killer Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrahams, Keegan Kline, Jerry Klein, Ron Logan, and the murderers. Therefore, the court grants paragraph 7 of the state's motion in limine over defense objection. That's it. Now, she does state in the previous paragraph, although I think technically there should have been more than one paragraph. This is just, in my opinion, a very lazy order. She states, the court having had the state's motion in limine under advisement, following a hearing conducted on August 1st and having heard and considered the evidence admitted, exhibits, arguments of counsel, defendant's supplemental submission regarding state's motion in limine and the state's response to defendant memorandum of law, grants paragraph 1 through 6 over defendant's objection, and grants paragraph 8 through 12 over defendant's objection. And then I talked to you about paragraph 7 already. Pretty lazy. Not issue, analysis, rule of law, conclusion, just denied. She could have done this from the bench at that hearing if that's what she was going to do. She is not going to be nominated for the appellate courts in the great state of Indiana writing like this. I've seen third graders that could write a little more thorough paper there. Now, does this surprise me? No. Based upon the reports that we had from the hearing, it didn't look good. And I said all along, when you have a alternate suspect, you have to show that basically the people were there, that they're the ones that did it. They had the opportunity, or they've done this before. Not just, hey, we think the Odinist did it, and that's it. But, and this is where I think a lot of times attorneys get wrapped around the axle, is they want to litigate this stuff, where they could have just laid a bombshell at trial and go into this. And a lot of this stuff is stuff that could have been done on cross-examination of a lot of these witnesses, kept them completely off guard. And now, through their over-litigation, the judge has determined that it cannot come in and will not be presented to the jury in any way. Sometimes people get wrapped around the axle. They get so entrenched in their litigation and their motion drafting skills, and they want to argue it, and they think they're going to win this case on some great legal argument. No. How many times have I said that before, ladies and gentlemen? Yes, occasionally you're going to win. Maybe you'll get a motion to suppress granted. No. Most trials come down to who has the best facts. That's why you send your investigators out. That's why you subpoena all those records. You subpoena both sides. Let's get emails from this person to this person. Let's see what was going on. Who didn't produce things like that? That's where cases are won in a criminal proceeding. Rarely is the law going to help the defense. And I told you all that alternate suspect wasn't going to carry the day unless you could actually show somebody was there standing over the bodies of those two young girls when the police showed up. Well, there's nobody there. So now Richard Allen just simply has to go based upon general denial. It wasn't me, right? The prosecution always has to prove that it was Richard Allen, not someone who looked like him, not someone uses his identity, but it was in fact Richard Allen that killed those two young girls. We know they got some good argument that it had to have been more than one person that could have done that. But of course, we've got the alleged confessions coming in of Mr. Allen to his wife and mother and everybody apparently in the jail, the prison. Things aren't looking good for Mr. Allen. He is not having a good day at all. All they had to do was call me. I could have walked him through the analysis. I thought it was a no-brainer. Sometimes people get too wrapped around motions practice. Just go try the damn case. Next, the special prosecutor's motion to revive the case against Alec Baldwin. Well, I think it is dead on arrival. That's right. The special prosecutor in the case of Alec Baldwin is fighting to have charges refiled against Alec Baldwin and has asked the judge to reconsider her decision to dismiss all charges against Alec Baldwin after the judge declared a mistrial this summer. Now, for those who don't know, Mr. Baldwin, that's right, the actor Alec Baldwin was charged with involuntary manslaughter for the death of cinematographer Helena Hutchins, who was shot and killed on that movie set, Rust, back in October of 2021. Now, the movie's director, Joel Souza, was also hit by a bullet as well. And Baldwin was, alleged to have been practicing a scene and was holding the gun when it discharged. But Alec Baldwin denies that he ever pulled the trigger. Now, as you may recall, we were bringing you this trial, streaming it to you live here on Crime Talk, when the judge, Mary Marlowe Summer, dismissed all charges with prejudice, which usually means it can't be refiled, against Alec Baldwin back in July, after his attorneys accused the prosecution of withholding evidence in the case. The evidence that is in question were several bullets that were given to investigators by a guy by the name of Troy Teskey. Now, Mr. Teskey, who is a former police officer, stored ammunition for Thiel Reed, who is Gutierrez's stepfather and a retired movie armorer. Well, that ammunition came under some scrutiny after the shooting when investigators were trying to determine where the live rounds actually came from. Well, Gutierrez's attorneys had asked an investigator in the case, Corporal Alexandria Hancock, to collect a series of rounds from Mr. Teskey and send them to the FBI to be tested. Hancock never did. And when Gutierrez's trial ended and Mr. Teskey had not been called to the stand, he took the rounds to the sheriff's office saying, I'm not sure what to do with these, but here they are. They may be related to the Rust shooting. You guys do with it what you want. Well, the prosecutor put a little memo together. The police did as well, but they booked it under a completely separate case number, so Alec Baldwin's attorneys didn't necessarily know that it was there. They should have booked it in under the Baldwin case and the Reed Gutierrez case. Anyway, there was a hearing held. The judge found that that was basically trying to hide this evidence. Frankly, I think it was of little exculpatory value to Mr. Baldwin in this particular case, but the prosecutor screwed it up. And even if it wasn't intentional, it sure looked like it was done intentionally because they booked it under a completely different case number, as though they were trying to hide the evidence. That's what the judge found. So Baldwin's attorneys filed a motion to dismiss, and they argued that his due process rights were violated when the prosecutors failed to hand over information about these bullets. But the prosecutor said it never occurred to her that the rounds could have been relevant to this case. Listen, if they're referencing the case, the shooting, it is relevant. You book it under the same case number. That's what you do. Anyway, the prosecutors claimed that there was no cover-up because there was nothing to cover up. And obviously she asked the judge to not grant the motion to dismiss. The judge did it, and ultimately the case was dismissed. Now that prosecutor says, hey, reinstate the charges here because the bullets in question were not key to the prosecution's case. And in the filing, they noted that Mr. Baldwin still handled his gun recklessly in violation of his own union safety bulletins and New Mexico state law, and the case against Mr. Baldwin was solely based upon his actions when the gun was in his hand. That's the argument that the prosecutor is making. Now, no hearing has been scheduled on that particular motion, and unless the judge reverses her decision, there are going to be no charges filed. I personally believe that motion is dead on arrival because this judge is not going to say that, well, maybe I made a mistake in the heat of the moment, dismiss the case. Maybe I should have taken a little time to reflect. No, it's done. It's over. I get it. The district attorney is trying to, or the special prosecutor is trying to save a little face, give it one more shot, give that old college try, but that case is over. That's right. The most recent school shooter and his father made court appearances today. Now, as you may recall, the Georgia Bureau of Investigation has arrested the father of the 14-year-old boy accused of killing 2 teachers and 2 classmates at a Georgia high school on Wednesday. Now, Colin Gray has been charged with 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty towards children after the attack on Wednesday. Now, his son, Colt Gray, has been charged with 4 counts of felony murder, and according to the police, more charges are expected. Now, Colin Gray reportedly told police that he had in fact bought the AR-style weapon for his son as a Christmas gift last year, and he bought it at a local store like most people would do, and it was for hunting. Apparently, the father even showed pictures of the hunting incident where he went hunting and killed his first deer, and he was very proud of his son. And his intent was to basically get his son interested in the outdoors, apparently, and get him away from playing video games. Anyway, like I said, that Christmas gift came a few months after law enforcement investigated the teen for online posts that threatened a school shooting. Investigators interviewed the younger Gray and his father, who told them that he had hunting guns that were locked safely away and that his son did not have unsupervised access to any of those firearms. Now, Colt Gray denied making any online threats, and investigators said they didn't find sufficient evidence for an arrest, and I would agree. That is not enough to arrest somebody. Anyway, the teen this Wednesday apparently opened fire at the Appalachia High School in Winder, Georgia, Wednesday morning. Like I said, killing the math teacher, Richard Aspinwall, and Christina Irmi, and 14-year-old students Mason Sher-Mahorn and Christian Angulo. 9 other people, 8 students, and 1 other teacher were also wounded. Now, the charges against the elder Gray are similar to those filed against the Crumleys. Remember James and Jennifer Crumley, parents of the Michigan school shooter Ethan Crumley? Ethan was 15 when he opened fire at that Oxford high school back in November of 2021, also killing 4 classmates and wounding 6 others. Now, Ethan Crumley pled guilty to all charges and was sentenced to life in prison. His parents were charged in what prosecutors described as a unique and novel theory of prosecution, the first time that a parent had been charged for a school shooting event. Anyway, they were convicted at trial, and they were accused of basically manslaughter in those cases for failing to get their son the help that he needed and buying him a gun that he in fact used in the shooting. They are both convicted, as I noted, and they received 10 and 15 years in prison in that particular case. Now, the father of the Georgia school shooter was quite upset when he appeared in court today for his first appearance, right after his son, Colt, learned that as a minor, he wouldn't be subject to the death penalty for the homicide charges. Now, the judge advised the older Gray that he could face up to 30 years in prison for each felony murder count, 10 years for each involuntary manslaughter charge, and cruelty to children. That's a total of 180 years. Now, ladies and gentlemen, no one's condoning school shootings. They're a bunch of cowards when they do this type of stuff. But if you go back and you look, and I talked about this in the Crumley thing, be careful what you wish for. They're coming. They're coming for more and more people, okay? Now, I know people are going to say, well, this guy shouldn't have bought his son a gun. He had issues. Well, what teenager doesn't have issues? Apparently, the young man was being bullied at school because he was gay. His dad was trying to get him interested in the outdoors. You know, do that manly stuff, I guess. Anyway, obviously the gun should have been locked up or something of that nature. But if, kids have hunting rifles, it's a thing in lots of parts of the country where kids can literally go out on their own and go hunting. So I got a real problem with the charge against the dad. Now, unless the dad basically said, son, today's the big day. We're going to go up there and shoot that school up, which I don't think he did. I don't think that he should be charged. But that's just me. But if we are going to have this kind of a civil negligent entrustment in criminal cases, parents, look out. It can reach to anyone. You lend your car to somebody, they go do something wrong. You give it to your kid, they go do something wrong, charge the parents. It goes completely against our criminal justice system, whereby we charge people for committing crimes that they committed, that they knowingly participated in. They knew it was going to take place. Not speculation that you could have prevented this, looking back, hindsight 2020. I know that may not be a popular view, ladies and gentlemen, but it's only going to get worse. Remember, I said, every time a prosecutor tries a new, unique legal theory of prosecution, and they, for lack of a better term, get away with it, everybody and their brother is going to be doing it. And that's exactly what's going to take place. Let's just charge all the parents for everything that every juvenile does. Why stop at school shootings? How about the juveniles that robbed a car? Charge them. The juvenile that ditches school? Charge the parents. I say bring it on. Be careful what you wish for, ladies and gentlemen. It's coming. Nowhere does the government ever try to cede power back to the individuals. They're going to do what they can to get the people that they want. And this is just one further step in doing it.